All right, welcome in everyone. Ready for another deep dive. Today we're going to be looking at a Supreme Court case, and it's a pretty interesting one, I think, because it gets into some of the nitty-gritty details of the justice system.
Definitely some nuance to unpack.
Yeah. The case is Mont v. United States, and basically what the Supreme Court had to figure out is, how do you deal with this situation where someone is serving a term of federal supervised release? They're out in the community, but still under supervision.
Right.
But then they get arrested for a new offense in a state court and end up detained pre-trial. So before they're actually convicted of anything new. The big question is, does that time they're sitting in jail awaiting trial, does that count against their federal supervised release or not?
It seems like a straightforward question, but as with so much in the law, the devil is in the details and how you interpret the specific language of the statute.
Absolutely. And in this case, the Supreme Court sided with the government, affirming a decision from the Sixth Circuit.
So, in a nutshell, what the court said is that generally, that pre-conviction detention time, it doesn't count towards your federal supervised release.
Right. So let's get into the weeds a bit here. What were the key arguments that the petitioner, the person appealing the lower court's decision, what were they trying to convince the court of?
Well, the petitioner's whole case really hinged on the phrase, is imprisoned in connection with a conviction. This is straight from the relevant part of the law, 18 U.S.C. section 362/E, which deals with what's called tolling of supervised release, meaning when does that clock pause?
Right. Probably.
And they were very focused on that present tense is imprisoned. They argued that it should be read quite literally, like at this exact moment while someone is in pretrial detention, they haven't actually been convicted yet.
Makes sense. You're innocent until proven guilty.
Exactly. So the petitioner's point was, at that point in time, they're not imprisoned because of a conviction. They're being held for other reasons, like to ensure they show up for court or because they might pose a risk to the community.
Right. They're detained, but not for a conviction, at least not at that moment. So in their view, that means the clock on the federal supervised release term should keep ticking.
Exactly. They argued the reason for the detention matters a lot here. Because pretrial detention isn't supposed to be punitive. It's not about punishing someone for a crime they may not have even committed.
But the other side, the government, they obviously had a different take on this whole in connection with the conviction issue.
Yeah. Their argument was, hey, that phrase shouldn't be read so narrowly. They said it's meant to encompass a broader range of situations where imprisonment is ultimately tied to a conviction, even if the actual conviction comes later.
So they're not just looking at a snapshot in time, they're looking at the bigger picture, the whole timeline of how the case plays out.
Right. And to support that view, they pointed to other parts of the Sentencing Reform Act where Congress used similar present tense language, but in contexts where it was clear they intended it to cover things that would be determined later on.
So they're saying, look, Congress uses this kind of language elsewhere, and it doesn't always mean right this second. We have to consider the context.
Exactly. And they also made a pretty compelling practical argument.
Okay, lay it on.
So their concern was, if you let pretrial detention toll supervised release automatically, you could end up with situations where someone essentially gets double credit for that time.
Double credit. How's that work?
So think about it. If they're detained pretrial and ultimately get convicted of that new state offense, that time they spent locked up will get credited towards their new state sentence.
Sure. Makes sense. Time served.
Right. But if the federal supervised release clock also stops during that same time, they're basically getting that chunk of time knocked off 2 different sentences.
Okay. Yeah, I see the potential issue there. It does seem a little like double dipping.
Exactly. The government argued that this would undermine the whole purpose of supervised release. It's supposed to be this period of reintegration after you've served your time. It's not about just sitting around waiting for a new case to wrap up.
And the government also brought up the idea that this interpretation could lead to some pretty inconsistent outcomes.
Definitely a concern for fairness. They argued that under the petitioner's view, 2 people in virtually identical situations could end up with different supervised release terms.
Yeah.
Imagine 2 people, both on federal supervised release, both get arrested on the same day for the same new offense. One takes a plea deal, maybe gets sentenced quickly, so their pretrial detention is relatively short.
Okay, shorter detention.
The other goes to trial, the case drags on, they're detained pretrial for much longer. But in the end, they both end up with the exact same sentence. Would it be fair for the person who sat in jail longer pretrial to suddenly have less time on supervised release just because of how long their case took to resolve?
I can see how that would seem pretty arbitrary, especially if the underlying offenses and the final sentences are the same.
Right. And they pointed to another practical challenge, and this one has to do with the probation officers.
The folks who actually oversee people on supervised release.
Exactly. The government argued that it's just not feasible for a probation officer to effectively supervise someone in the community when that person is simultaneously locked up in a county jail awaiting trial on a new case.
Yeah, kind of hard to do home visits or drug tests when they're behind bars.
Exactly. It limits what a probation officer can do to actually help that person reintegrate into society.
And during oral arguments, didn't Chief Justice Roberts make a similar point?
Yeah, he brought up this idea that while the state might know where that person is physically located because they're in jail, that doesn't equate to the kind of supervision and support that's supposed to happen during federal supervised release.
It's about more than just knowing where someone is sleeping at night.
Right. It's about helping them transition back to life outside of prison, getting them connected with resources, making sure they're following the terms of their release.
Okay, so lots to unpack there. But before we get to the 10th chair and our own thoughts on this case, I want to circle back to something the government acknowledged. They admitted that the law could have been written differently, right?
Yeah. They conceded that Congress could have used more explicit language. Like they could have said, after a conviction, or considered to have been imprisoned in connection with a conviction.
That would have made things a little clearer, wouldn't it?
It might have. But their point was they didn't use that language. They opted for this broader, more inclusive wording. And that was intentional, they argued.
So they're basically saying, look, if Congress wanted to exclude pre-conviction detention from tolling, they would have said so more directly.
Precisely. They're putting a lot of weight on that specific choice of words.
Okay, so we've heard from the petitioner, we've heard from the government. Now it's time to put on our judge robes and step into the 10th chair. Let's imagine we're that hypothetical justice on the Supreme Court. What's our take on all of this?
All right, well, from the 10th chair, I see where the petitioner is coming from. That focus on the literal wording of the statute, the emphasis on that present tense is imprison. It has a certain logical appeal. And on a gut level, it makes sense to think that if someone is locked up, regardless of the reason, they're serving some kind of time.
Right.
But I have to say, the government's arguments about the big picture, the overall goals of supervised release, and the potential for unfair or inconsistent outcomes, those resonate with me more strongly. Supervised release is really about guiding someone back into society, providing structure and support to reduce the likelihood that they'll end up back in prison.
It's about setting them up for success, not just letting the clock run out while they're dealing with a whole new legal mess.
Exactly. And allowing that supervised release period to just tick away while someone's sitting in pretrial detention, potentially for something totally unrelated to their original federal offense, it just doesn't seem to align with that purpose.
Especially when you consider that, as the government pointed out, probation officers have limited ability to provide real supervision when someone's locked up.
Right. They can't really fulfill those core functions of supervised release, like connecting people with jobs or housing or treatment programs when they're stuck in jail. And honestly, while the statute may not be the clearest on this point, the interpretation that favors tolling supervised release when someone is imprisoned for conduct that ultimately leads to a conviction, that just seems to make the most sense practically.
And avoids those potential pitfalls of giving people double credit or having wildly different outcomes based on how long their pretrial detention happens to be.
Yeah. From this 10th chair, it seems like that approach aligns better with the intent behind the supervised release system as a whole.
Well, there you have it, folks. That was our deep dive into Mont v. United States, a case that really gets into the weeds of how our legal system handles these sometimes overlapping layers of federal and state offenses and the challenges of supervising people in the community when they get caught up in new legal trouble.
A real head scratcher in some ways.
Definitely. Now, here's something to chew on. In light of this Supreme Court decision, what do you think this means for those individuals who are trying to rebuild their lives after a federal conviction while also facing new state charges? Does this ruling help or hinder their efforts to successfully reintegrate into society?
Lots to think about there, for sure.
Thanks for joining us on this deep dive. Until next time.
See you then.